Workplace injuries can be catastrophic. And if you've been injured in the workplace and you have questions on how long you have to file a claim and what happens after you file a claim, then this is the video for you. I'm Nunnally, and I'm a personal injury attorney here in Houston, Texas. With my law partner, Matt Allen, we fight for the rights of injured Texans, especially those who've been injured at the workplace. Today, I'll explain the process for filing a claim for injuries sustained at the workplace, and also explain how long you have to file that claim before you lose your right. First, it's crucial to understand that in Texas, we have what's called a statute of limitations, which is a rule that says how long any person has to file a claim for any action in a lawsuit. For injury sustained in a workplace injury, that statute of limitations is 2 years. What does that mean for you? That means starting the day you are injured, you have 2 years to file your claim, or you are no longer allowed to claim damages against those who injured you. That is why it is so important that when you are injured, you quickly consult with and retain an attorney to advance your rights against those that hurt you. So what is a negligence claim? In summary, it's when someone owes you a duty to keep you safe at your workplace, and they fail in that duty, and you are injured. When this happens, you have a negligence claim against potentially your employer, the person who contracted your employer, or other people on the work site who harmed you due to their direct actions or direct inactions. Now, when and if you're injured on the job, there are several steps that we recommend any injured party takes. They are the following. 1. Quickly consult with and hire an attorney. This is highly important because you want to get representation right away to help you investigate the incident. This brings us to number 2. Once you've chosen an attorney, that attorney should be immediately investigating, consulting witnesses, and trying to uncover as many facts as possible of what occurred that hurt you while those facts are still fresh in the minds of those who witnessed them. Step 3. Once your case has been fully investigated, your attorney will either file the lawsuit right away, or in some cases, send a demand letter to those that hurt you, asking for compensation. Depending on your facts and your attorney, either one of those routes could be pursued. However, most cases in Texas do not reach settlement stage or monetization until many months after a lawsuit has actually been filed and the parties have pursued what we call discovery. Discovery is when your lawyers and lawyers for those who you have sued ask questions, request documents, and interview witnesses to find out what happened. Once that has occurred, which in most cases can take between 6 and 18 months, is when most cases for negligence resolve. For those cases that don't resolve in a settlement after a lawsuit has been filed, trial is the next step. Jury trials in Texas in most counties do not get called until 18 months or 2 years after a case has been filed. And as a plaintiff, you will have to be patient in waiting your opportunity to having your case served. It's important to remember that even though a lawsuit is filed within the 2-year statute of limitations, it may not go to trial. In some cases, in fact most cases, lawsuits for negligence will settle between the parties. Workplace injuries can be complex, especially in the energy industry of our state. You need to have an attorney who understands refineries, the oil field, or just work in industrial settings. For those reasons, it is always valuable to consult and retain an attorney quickly after you are injured. At Allen & Nunnally, we are happy to assist you with these types of cases, and we have experience in both investigating and trying these cases. Remember, with Allen & Nunnally, you will have no better friend, and those that injured you will have no worse enemy.